Last week, the Supreme Court issued its ruling in the court's first Second Amendment case since its landmark decision in New York State Rifle and Pistol Association versus Bruen, a decision in 2022 that vastly expanded Second Amendment rights in the United States. In United States versus Rahimi, the justices ruled 8-1 in favor of upholding a 1994 federal law that bans persons with restraining orders from having access to firearms. The law applies only to certain restraining orders issued in state court that contain a finding or language regarding somebody posing a physical threat to an intimate partner or other family member. And in this case, Zackey Rahimi was subject to one of these orders after he had abused his intimate partner. While the outcome in Rahimi was somewhat expected, it also offered our first glimpse into how the conservative majority court would handle gun rights cases post-Bruen and whether the court would clarify its text history and tradition test. In this episode of the Duke Law Podcast, we're taking a closer look at these issues and what Rahimi could mean for gun rights and regulation going forward. I'm your host, Andrew Willinger, the Executive Director of the Duke Center for Firearms Law. And joining me today on the podcast are Duke Law professors Joseph Blocher and Daryl Miller, both Second Amendment and constitutional law scholars, as well as the faculty co-directors of the Duke Center for Firearms Law. Joseph and Daryl, it's great to have you here today.
Thanks for having us.
Nice to be here.
So let's jump right in. I wanted to ask both of you, what were your initial reactions to the decision that we got last week in Rahimi? And was that decision about what you had expected coming out of last November's oral argument?
Yeah, I think the result certainly was no surprise based on the oral argument and just frankly based on the facts of this case and the law being challenged. I think most of us expected the federal government to win. Solicitor General did a brilliant job at oral argument. And I think based on the questions, we had a sense that the court was going to uphold this law. I mean, there were still some surprises, which we can unpack, including just that it took 100 pages of opinions to get to a result, which I think, again, most of us thought was justified based on the law and the challenge. There were some details that were a little surprising to me. I didn't think that it would be the Chief Justice writing. My guess would have been Justice Barrett. There were some things in the opinions that weren't as prominent as I'd expected. I thought we might get some discussion of due process and other issues. But generally, I think this is the result that at least seemed to me was in the cards.
Yeah, I totally agree. I think from the timbre of the oral argument, we knew how this was going to come out. And the real question was whether they were going to get a kind of divided opinion or not. And so I was actually surprised that we ended up with an 8-1 decision where everybody signed on to a majority, although the 100 plus pages that Joseph just mentioned are really about sort of spinning what the majority decision actually is. So we didn't get a fragmented opinion, which would have been the worst outcome, I think, worst plausible outcome. And we got a solid majority, but we got a lot of sort of working the refs, as it were, about what the majority decision actually means and says.
Right, and I'll just add briefly here, I think this was pretty much the decision I expected. I was a little surprised that we only had Justice Thomas in dissent, that he didn't get Justice Alito perhaps to join him. And also it surprised me a little bit how long the court took to rule in the case. I think part of that might be because we had a number of concurrences here and that may have held up the process, but also worth noting that the court has a packed docket with the number of high-profile decisions and seems likely to keep releasing decisions this year all the way through the first week of July. To move on to sort of the practical consequences of the decision, I wanted to ask how important you think Rahimi is for efforts to regulate guns at the federal and state levels, and whether this ruling is really a win for advocates of stricter gun laws.
Yeah, I think it was actually a qualified win for advocates of gun safety. The need to keep guns out of the hands of persons that are a credible threat of domestic violence is a really pressing social issue. The correlation between violence, intimate partner violence, guns, and homicide is well documented. So I would say that this is a win. Why I say it's qualified is because the opinions are really jostling about with what level of generality, what principle is animating the actual outcome. And so even though I think it's a qualified win, it definitely gives a lot of grist for persons that want to defend common sense gun regulations. There's a plenty disagreement even within the majority and the concurrences that it leaves a little bit up for grabs exactly what the downstream effects will be after Rahimi.
I pretty much agree with that. I think this was really I would call it maybe a mixed bag. To your first point, Daryl, I agree that we shouldn't sort of undersell how consequential the decision could be. And it goes beyond potentially just the federal law at issue here. You have state laws in almost every state that do the same thing, that restrict gun access by those who are subject to domestic violence restraining orders. I think this decision is a strong endorsement of those laws as well. And you also have the background check system, which came up in the briefing, that it's not just about how often this provision is charged, but that people who are subject to these restraining orders are entered into the federal background check system and prohibited from purchasing guns. On the other hand, it's not even clear to me that the majority opinion endorses the statute here across the board. You do have a portion of the statute that applies whenever the underlying restraining order contains certain language barring future violence, and the court says it doesn't need to necessarily decide whether that is constitutional because the question wasn't presented in this case.
Yeah, I mean, I think it's certainly a win, and it's notable this is the first time that this court has upheld a gun law in a Second Amendment case, which is, just in itself pretty important. And as Daryl mentioned, the practical importance of this law, which you see a little bit of discussion of that in Justice Sotomayor's concurrence, just about like the actual facts here, the connection between intimate partner violence, guns, and homicide. So that's big and that's good. My initial reaction was that it's about as narrow a win as the government could get. There's various phrases in the majority opinion basically saying all we're holding today is that it's constitutional to disarm a person who presents a credible threat of physical violence to another. And if that's a hard question, then I think a lot of other laws are going to be called into question going forward, because here, again, just on the facts of Rahimi, we have a person whom a judge has made an individualized determination presents a credible threat based on some pretty egregious facts. If that's not just, sufficient but necessary to disarm a person under the Second Amendment, then I think this really is a narrow win. But on the other hand, we get, some really useful, I think, guidance and language about just how broad the principles are that underlie that holding. And I'm sure we can unpack that some more. In fact, let me turn that into a question. I mean, what is the rule or principle that you take away from the majority opinion here? Like, does this settle the constitutionality of any other kinds of gun regulations or give some insight into how the justices might approach sort of future cases?
Well, I think that you mentioned it earlier in your response to Andrew's question, which is, it's this sort of credible threat of physical violence. And, that's a principle that you can disarm somebody that's credible threat of physical violence. But the case itself doesn't really give quite as much detail about at what level of generality, at what time frame removed does that principle operate. That is, I can imagine a scenario in which those looking to really narrow or understand Rahimi in a very narrow sense would say, yeah, you need an actual, credible threat determination for each individual time. I can imagine others that would want to support more categorical rules to say, no, you can say, for example, violent felons or other kinds of persons present a credible threat of physical violence to the other. Why? Based on probabilities of their behavior in the past. And that's what we mean. And that will be, I think, the grounds on which there will be lots of debate going forward.
I think that's right. I mean, my sense is that this decision and the narrowness of this decision kind of commit the court to taking a bunch of Second Amendment cases in the coming terms. But to this specific question about, what other types of gun regulations might fall under this rule that the majority articulates, I actually think it's really interesting to look at red flag laws, which exist at the state level, and I think about 20 states or a little more than that. And those are actually modeled after the domestic violence restraining order bans of the type that are at issue in Rahimi. They similarly apply after a judicial finding on an individualized basis that somebody presents a threat to themselves or others. And so I think, you could probably read Rahimi as a pretty strong endorsement of those laws, which have mostly been upheld, but still, that's a potentially significant takeaway.
So, what was your sense of whether the majority actually walked back any of the Bruin history and tradition test? I mean, one of the reasons we were paying attention to this case in particular was to see what kind of direction the high court would give to lower courts. Do you think that they actually gave clear direction to lower courts on cases going forward?
Yeah, on that, I think my answers would be yes and no. And yes, in that they, I think, did maybe not walk back, but at least clarified some of Bruin's test. And the no to the did they give clear direction. I mean, the way I see it is that the majority opinion, in a very, I think, significant way, rephrased Bruin's holding. What Bruin says is that in order to be constitutional, a modern gun law has to be consistent with this nation's tradition, historical tradition of firearms regulation or weapons regulation. What the majority says is that in order to be constitutional, a modern gun law has to be consistent with the principles underlying this nation's historical tradition of weapons regulation. And that might seem like a slight move. It's just a couple more words, but introducing the word principles there, I think, invites, going back to your earlier point, Daryl, invites consideration of questions at a higher level of generality. And the majority does emphasize, and this comes through in some of the concurrences as well, look, we said in Bruin, you don't need to find a historical twin, or as Justice Barrett puts it, even a cousin, right? We're not looking for one-to-one comparators. We're looking for the underlying reasons that motivated the historical laws and the modern laws. And in that respect, I do think it's potentially significant. Now, is it clear guidance? I don't think so. I think that we're still going to see the same parsing of historical examples. I think the way these cases are litigated is not going to change much. And I think still we're talking about the Bruin standard and the Bruin test maybe as modified by Rahimi rather than the Rahimi test. I mean, it still looks to me like Bruin is sort of the central place to go.
And I'll just highlight a couple other places where I think you might say that the majority or some group of justices maybe is intending to walk back Bruin or at least to sort of cabin Bruin in certain ways. So first, there's some language in the majority opinion that talks about using the same level of generality in terms of the right side and the regulation side. I know that's something we had talked about coming out of oral argument. And so I think that's potentially very helpful and may clarify Bruin in some ways for lower courts. You also have Justice Barrett in her concurrence rejecting the idea that founding era legislatures maximally exercise their power so that you can make assumptions based on the absence of regulation. And so I think that's also potentially significant. But my takeaway in general would be that while this may mitigate or sort of implicitly overrule some of the strictest interpretations of Bruin that we've seen at the lower court level, other than that, I don't know that it changes too much. So moving on, after reading Rahimi a few times, it seems to me that the majority here is really kicking the can down the road on a number of issues and leaving them for future cases. So I wanted to ask both of you, what do you expect the next few years of Second Amendment jurisprudence from the court to look like?
Right. Well, the best outcome, I think, for lower courts in particular would have been a Rahimi that totally clarifies the field, how this text history tradition / analogy to history test was supposed to work. We didn't really get that. So I think we're in for a steady diet of Second Amendment litigation for the foreseeable future. There's enough little Easter eggs, throughout this opinion to cater to any kind of brief or opinion. You've got some, of the justices talking about high levels of generality for principles. You've got others saying, no, principles aren't really what the law is. It's really about the text. There's so much grist for the mill, depending on what your advocacy position is on guns, that I think that we're going to get a lot of split decisions in lower courts, even after Rahimi. And the Supreme Court is going to have to take up these cases one by one and generate doctrine to clarify the field, just as they do with any other new right.
Yeah, I completely agree. I mean, I think what we're looking at here is not yet a period of normal science. I don't think we yet have enough of a framework, frankly, even to say, what does Rahimi say about prohibitions on large capacity magazines or prohibitions on guns in sensitive places? I think the answer to that is very little, other than that you have to, reason with regard to these historical principles. But I'm not sure that those cases got changed very much otherwise. And so, and those cert petitions are pending on those issues and lots of others. I mean, it's not even 100% clear to me how Rahimi clarifies the constitutionality of G1, the felon prohibitor, about which there's obviously a ton of pending litigation. So my prediction's the same as Daryl's. I mean, I think the court will and kind of has to grant a lot more Second Amendment cases, and that in itself will be really be something, because we went through this long period between Heller, McDonald, and then Bruen of essentially nothing at the court. Tons of petitions, and most of them rejected. And now I think we're entering an era where, like with the First Amendment or other areas, the court's just going to have to build some more doctrine. And the last thing I'll say on that is that it's true in the lower courts too. Eventually, at some point, we'll have some doctrinal tests, some precedent that will govern these issues such that we're not, I think, going to see quite as much sort of original historical research in every case. Like eventually we'll have circuit precedent about whether G1 is constitutional or under what conditions, instead of lower courts having to do this work on their own. But we're not there yet. And until the court takes some more cases, I'm not sure we will be.
And I think it's fair to say that we ought to talk about the different nature of the Intermediate Appellate Court now. I mean, this came up from the Fifth Circuit, which is essentially saying, well, all right, it's a new day for Second Amendment adjudication, so everything that you thought was common sense now is up for grabs. And those judges are still on the court. Those judges have lifetime tenure. Those judges, have friends and allies on the ideological spectrum in other courts. I think it's a different feeder system for these sort of cases now in the federal court system than it was after Heller or after McDonald.
And Joseph, you had mentioned the cert petitions that the court is actually holding at the moment and has sort of held since it took Rahimi. And I think what they do with those petitions will be an important guide in terms of thinking about the next couple of years. The court has petitions in a number of cases dealing with 922G1, the federal ban on convicted felons possessing guns. And just a couple of days ago, the federal government actually filed a supplemental brief in those cases urging the court to take up that question. And they may do that as soon as next week. The court also has a petition in the Daniels case, which involves the unlawful drug user ban that has received a lot of attention due to the Hunter Biden prosecution. And so those are the types of cases that I think we might see the court grant cert in. And it seems to me like it could be that this is more of a sort of gradual process over the next few years. The court took Bruen, and that was a sea change in Second Amendment law. But now that it seems to me the justices may be stepping back a little bit and saying, we want to take things slowly. And it could be that they're also just not, united in terms of their view on these issues. So one aspect of the Rahimi decision that caught my eye is this portion in the majority opinion that, sort of goes out of its way to reject the government's argument in the case that the relevant principle here is irresponsibility, or, as the government alternatively phrased it, somebody who's dangerous with respect to firearms. So I was curious what both of you made of that paragraph in the opinion, and whether you still think that there needs to be kind of a categorical principle of some kind, and what that principle might be.
Yeah, I mean, it feels to me like there has to be room for some kind of categorical, that is sort of like legislatively determined, group-based prohibitions, because otherwise we would be looking at a world where every single person, in order to be constitutionally disarmed, would have to be subject to an individualized determination by a judge. And that just can't be right. I mean, a person who is convicted of a violent felony, say homicide or something, might not also be found individually to present a threat going forward. They've just committed homicide, right? It can't possibly be the case that that person is constitutionally entitled to a weapon under the Second Amendment, right? I think there's going to be a mix of individualized and categorical determinations. I think, given the lineup on the court, it does seem to me that a dangerousness principle will eventually prevail. I mean, it's one of the reasons that I thought Justice Barrett would write this opinion, that she'd written her dissent in the Cantor case on the Seventh Circuit, essentially endorsing a dangerousness principle, which I think would have easily resolved this case, given that Zacky Rahimi is, by any definition, dangerous. And the court could have decided more in Rahimi had it gone, I think, and embraced that kind of principle instead of the maybe more narrow articulation of it as a credible threat of physical violence to another person. But, when the court takes up, for example, G1, the felon prohibitor, then I wouldn't be surprised to see dangerousness sort of reappear.
This is one of the sort of give and take of the opinion itself, which is, in some places it's trying to say, there are principles at work. In other places it's trying to be really narrow and saying we're just deciding this particular type of case with a particular kind of person that poses a credible threat. We're not saying anything about these other sort of categorical prohibitions. They do, as you say, go out of their way to talk about irresponsibility is not a legitimate reason to permanently disarm somebody, which has lots of implications, has implications for prohibitions on undocumented immigrants that have firearms. It has implications for those that, might be users of illicit drugs, especially if those drugs are not correlated with actual risk of physical violence. So the implications are pretty broad in basically carving out and saying that irresponsibility is not alone sufficient to support a prohibition on possessing firearms.
Right. I think I agree with Daryl that I didn't read this portion as necessarily rejecting the dangerousness aspect of what the government was arguing. It almost seemed to me, to be honest, that this was kind of a red herring in the case, that it was rejecting an argument that the government hadn't made, and that the use of this term irresponsible had sort of conjured up images in the minds of some justices that maybe somebody could be prohibited from possessing guns because they didn't take out their recycling, right? And I don't think that anybody was really asserting that. But in any event, I think I agree as well that dangerousness seems most likely to kind of carry the day, and maybe that will happen in a nonviolent felon case. So a final question here. I mentioned earlier that I had been a little bit surprised that it was only Justice Thomas who dissented. He's, of course, the author of the majority opinion for a 6-justice majority in Bruen. But here he's alone, essentially arguing that the majority misconstrues the test that he articulated in that case. So is it fair to say that in some sense the rest of the court has taken control over Second Amendment law away from Justice Thomas?
Yeah, I think that to the extent that Rahimi sort of shunts the author of Bruen into a dissent, it basically shows that Thomas has lost control of the terms of the debate about how Bruen is to be understood. All cases subsequent to Rahimi are going to cite Rahimi to interpret Bruen, not interpret Thomas's interpretation of Bruen. So, yeah, I think that's really fair to say that it's now multivocal on the court, which, the 100-plus pages of opinions with many, many concurrences are all ways of each justice construing what they meant when they joined Bruen or what they understand Rahimi to be.
I have to say, I think it's just a remarkable dissent. If there's any law that I would think might be unanimously upheld by the court, it would be one where a judge has made an individualized determination that a person presents a credible threat of physical violence to another person, which is what we have here, and some astonishing facts, which again, the majority starts with. Maybe this could have been unanimous, and maybe if it had been, maybe if it hadn't been Justice Thomas who'd authored Bruen, maybe they could have commanded sort of unanimous support. But his own application of the Bruen test, I just think is just astonishingly wooden and narrow. And although the Bruen test says, yeah, you don't have to find an historical twin, it certainly looks like that's what Justice Thomas is searching for. And I say that, he in Bruen says there's 2 metrics we use to compare the historical and the modern laws, why and how they burden the right to armed self-defense. And even here, he's like, yeah, the whys are the same between the historical and the modern laws. And then he really sort of zeroes in on how, the historical prohibitions weren't as broad as this one or something. I mean, if he's not going to uphold this law, it feels to me that he's going to vote against the government in basically every single case going forward. And maybe that's not news, but I was a little surprised by it. I am, to go back to your point, though, Andrew, I did expect maybe a little bit more from a Justice Alito, possibly even a Justice Gorsuch, on the kind of due process-y aspects of this case, because the underlying thing is a civil order. And we didn't get that. So that's one dog that didn't bark.
So what's interesting about that is that Justice Thomas had offered the how and why as a way of sort of understanding how to do the analogical process, how to do levels of generality. And, I'm on the record of saying that I think it just simply restates a levels of generality problem. You can state, the how and why of a regulation at multiple levels of generality, as shown exactly by how Rahimi creates this dissent.
And I think that's going to be the final word for this episode. Daryl and Joseph, thanks so much for a great discussion and for sharing your insights on these important matters.
Thank you.
Thanks for having us.
As you all know, we'll continue to cover these issues at the Duke Center for Firearms Law, on our website, and through our Second Thoughts blog. both of which you can find at firearmslaw.duke.edu. You can also follow the center on X, the site formerly known as Twitter, at Duke Firearms Law. And be sure to follow the Duke Law Podcast wherever you get your podcasts. Until next time, go Duke.